Hello and welcome to The Entrant. The topic for today's discussion is ancient criminal law in India. This topic holds a great importance when it comes to know the emergence of the present criminal law in India. So, firstly, we should know that the first codified law in ancient India was Manu Smriti, which had references of all the important crimes that now exist in IPC, like theft, cheating, assault, rape, murder, etc. And it also consisted, Manusmriti also consisted various forms of punishments like fine, banishment, forfeiture of property, which is now broadly the punishment forms in IPC also. In Manusmriti, the caste played a major role in deciding the punishment, and there was exception to given to the juveniles and also the elderly people. Further, talking about the judiciary in ancient India, it was in the Vedic period when the social and state information was yet to be completed. Dharma. Dharma was the main source of or sole source of law at that time. Sacred law, evidence, history, and edicts of kings are the four legs of law. Before the conquest of India by the Muslims, the penal law prevailing in India was the Hindu criminal law. It is now well established that in ancient India there existed a systematic and well defined criminal law. Ancient Smriti writers were also fully aware of various purposes served by punishing the criminals. Manu, Yajnavalkya, and Brihaspati state that there were four methods of punishments, namely by gentle abomination, by severe proof, by fine, and by corporal punishment, and declared that these punishments shall be inflicted separately or together according to the nature of the offense. The punishment served four main purposes: to meet the urge of the person suffered, for revenge or retaliation, as deterrent and preventive measures, and for reformation or redemption of the evil doers. Now, in the fourth slide, we discuss about criminal justice in ancient India. It was considered as the aid and development of both criminal and civil legal systems in India, which date back to the ancient period to a land that was ruled by various kings of India right from 3000 BC to 101 CE and beyond. This country had a similar system of law for well over 4,000 years. No other country in the world can claim such a credit, and even though this land was divided into hundreds of small political kingdoms, the law of the land called Niti and Dharma given by the great Hindu lawgiver Manu were common or similar in nature. The Dharma Sutras and the Kautilya's Arthashastra, however, present a more detailed and well-developed system of criminal adjudication prevailing in their time. The Niti Shastra mentions king as the fountain of justice, and it was his sacred duty to punish the wrongdoers, and if he flinched from discharging his duty, he was bound to go to hell. Now, moving on to the fifth slide, we look at the critics of ancient criminal law. So, Henry Maine described the legal system of ancient India as an apparatus of cruel absurdities. An Anglo-Indian jurist made the following remark about what he called the Oriental habits of life of the Indians before the British turned up in India. It is a record of experiments made by foreign rulers to govern alien races in a strange land, to adapt European institutions to Oriental habits of life, and to make definite laws supreme amongst peoples who had always associated government with arbitrary and uncontrolled authority. Ellen Gladhill, a retired member of the Indian Civil Service, wrote that when the British seized power in India, there was dearth of legal principles. For Bernard Cole, the ancient constitution rendered Indian history as antique, static, and theocratic. Now, moving on to the sixth slide, we discuss the criminal law in Mughal period, which has been implemented by Shariat or the Islamic law of crime and punishment, which are the main sources of which were Quran, the Hadith, the Ijma. The ecclesiastical cases were separated from the criminal and civil suits. The Darbar of the Sultan constituted the highest civil and criminal court of justice, which took original as well as appellate cases. Below the sultans there was the court of Qazi-i-Quzat or the Chief Justice of the empire. Muqtasib, the censor of public morals, acted as police cum judge in the observance of the canon law by the Muslims. The village panchayats enjoyed the sanction of the state to administer justice according to the local tradition, customs, and the personal law of the populace. The penal code was severe. Physical torture and capital punishment constituted an essential part of it. Now, we can discuss the punishment under Mughal period, which is in the seventh slide. So the first form of punishment was kisa. In this, the retribution in the cases of murder and intentional mutilation were included. So if the family of the offender agrees that the offender would be punished with the same act he did to the victim, then the offender can be punished with the same act. Now the second form of punishment is diya, in which the compensation is given to the victim's family. Now the third form is had, which meant boundary or limit. In criminal law, it meant specific penalties for specific offenses. Now, the last form of punishment was tazir. So it meant discretionary punishments. So these punishments were inflicted at the discretion of the judges, as there were no fixed rules to prescribe such punishments. Now coming on to the conclusion, that the essential object, I would just like to say that the essential object of criminal law is to protect society against criminals and lawbreakers. For this purpose, the law holds out threats of punishments to prospective lawbreakers as well as attempts to make the actual offenders suffer the prescribed punishments for their crimes. Therefore, criminal law in its wider sense consists of both substantive criminal law and the procedural criminal law. Substantive criminal law defines offenses and prescribes punishments for the same, while the procedural law administers the substantive law. So I hope that it was a very useful and simple, clear understanding of ancient criminal law in India. Thank you.